Thanks for jumping on this Monday afternoon. I have with me my friend and longtime colleague, fellow federal prosecutor, fellow homicide prosecutor, Kevin Flynn. You always hear me say, probably too often, that I was a 30-year federal prosecutor. Kevin's got me beat by 5 years. He was a 35-year federal prosecutor, and primarily violent crime and homicides. That was kind of our stock and trade. And so when I saw what was published regarding Lindsey Halligan's first court appearance in the Comey case, it was pretty shocking. It looked more like something that the satirical online publication The Onion might present, although it would be a little bit too incredible for them. Um, but let me just explain the process, and then Kevin and I are going to have some fun with this, and I hope it will be fun for you. We are going to recreate Lindsey Halligan's first court appearance by reading a very short paragraph, question and answer from the judge to Halligan. I've asked Kevin to play the judge. I will play the incompetent prosecutor, Lindsey Halligan. And let me just set this up for you, even though you are all well acquainted with the facts. It seems that Jim Comey didn't commit any crimes. It seems that there was insufficient evidence to actually legitimately indict James Comey, former FBI director. That apparently didn't matter at all to Donald Trump because he was going to be prosecuted, evidence be damned. And when the former United States attorney in the office that's handling the Comey case, the Eastern District of Virginia U.S. Attorney's Office in Alexandria, Virginia, the former U.S. Attorney, Eric Siebert, appointed by Donald Trump, declined to prosecute James Comey because he didn't have a case to bring. Trump fired him, or probably more accurately, Eric Siebert resigned, but Trump then claimed he fired him. Whichever way that actually shook out, Siebert left. Donald Trump took one of his employees, his staff members at the White House, Lindsey Halligan, former insurance lawyer, former beauty pageant contestant a couple of times over. And she was in charge, before she was made U.S. attorney, of essentially whitewashing and scrubbing facts from the Smithsonian Museum. And of course, that qualified her to be top prosecutor in Virginia. Not. But she went over there, and within a couple of days, lo and behold, James Comey was indicted. And what we now know, courtesy of a short transcript excerpt, she went in to the grand jury, she obtained an indictment, and then she presented that indictment to the judge. It's called the indictment return, and the judge has to sort of bless it, and then it becomes part of the initiation of the criminal case against James Comey. So, Kevin, thanks. I don't know if there's anything you want to say before we jump into our recreation of Lindsey Halligan's first court appearance in the Comey case.
I think the only thing that I'd say, Glenn, and first, thanks for having me. It's always a pleasure. Is that so? The way we've set this up, I'm supposed to be the judge, and you're going to be the prosecutor. You had 30 years in the job. You and I both probably appeared literally thousands of times in court. This was Lindsey Halligan's first court appearance in a criminal case. You are going to have to play her. And with your level of experience and our mutual levels of experience, but you're playing the role here. I think this is an acting job that would be too tough even for your friend Robert De Niro to pull off. But have at it. Good luck.
I am going to try to give the role of Lindsey, to do the role of Lindsey Halligan well, I guess not justice. I'll try to do it in justice. That's what I'm going to try to bring to the role.
All right. So setting things up here, this is the court, the judge, me, and starting off, and you are Lindsey. And so the judge says, so this has never happened before. I've been handed two documents that are in the Mr. Comey case that are inconsistent with one another. The one says it's a failure to concur in an indictment. It doesn't say with respect to one count. It looks like they failed to concur across all three counts. So I'm a little confused as to why I was handed two things with the same case number that are inconsistent.
Now, I'm Lindsey Halligan. So I only reviewed the one with the two counts that our office redrafted when we found out about the two counts that were true billed, and I signed that one. I did not see the other one. I don't know where that came from.
You didn't see it?
I did not see that one.
So your office didn't prepare the indictment that they...
No. No. I prepared three counts. I only signed the one, the two count. I don't know which one with three counts you have in your hand.
Okay, it has your signature on it.
Okay. Well, end of transcript. Thank you. Acting. All right, Kevin, I want to jump in here, but I want to give you first crack. What do you make of that hot mess in what is one of the most consequential criminal prosecutions in our nation's history, a former FBI director?
Well, what's interesting to me is it's an incredibly consequential matter, but the hearing that she appeared at and is really one of the more inconsequential parts of the process. It really needs to be emphasized how routine this hearing was. And how this is the equivalent for a prosecutor of being able to walk from one side of the street to another, and not find yourself getting hit by cars or somehow or another impeding traffic. Literally, this is something that is just routine. It is commonplace. All prosecutors know how to do this. But the bottom line is you have to remember, this literally was the very first time that Lindsey Halligan had appeared in a courtroom in a criminal case. And she was appearing as the United States Attorney for the Eastern District of Virginia, one of, I think by most people's estimate who are in the business, the three most consequential U.S. attorneys' offices in the country. And she was doing so in a hearing, as you've recognized and observed, that dealt with the indictment of a former FBI director. So I don't want that what I'm going to say next to be taken as being disparaging to beauty contestants, but I somehow doubt that the questions that were asked of her at any of her contests were on the level that this judge was asking her here, which may indicate the extent to which she was out of her depth.
Yeah, and as I'm going to summarize what Kevin just said in fewer words, it's really hard to fuck this hearing up. And that's a legal term, at least from Jersey, where I come from. And the reason I say that is, let me just give the audience the nuts and bolts. So when the grand jury votes out an indictment against somebody, they render a true bill, which means at least 12 of the grand jurors voted in favor of indicting one or more felony charges because there was probable cause to believe a crime was committed and the person that the prosecutors are seeking to charge committed it. Then what we just read is like just this perfunctory court hearing where literally the prosecutor delivers to the judge the indictment that the grand jury returned. The judge blesses the indictment, and now the criminal case is begun in earnest. She couldn't even get that right. She had two indictments. The judge couldn't make heads or tails out of, which one was the true bill, which one did the grand jurors vote, down, no bill, no true bill. She couldn't answer questions, apparently, including about things her signature appeared on. This is a hot mess. And, let me ask you this, Kevin. I have been thinking about this ever since I read the horror show of that transcript. As we both know, it is very difficult for defendants to ever pierce the veil of grand jury secrecy and get discovery on what in the world went on before the grand jury. There are lots of great policy reasons why we don't expose what goes on in the grand jury to public view, and it has nothing to do with prosecutors wanting to indict ham sandwiches and run roughshod over the grand jury. We need to protect the anonymity of the grand jurors. We need to protect the names of the witnesses who appear before the grand jury. We need to protect the people we're investigating in the event they are not indicted, so we don't wrongfully kind of, put their stuff in the public square for people to see. Lots and lots of important reasons to keep it secret and not allow a defendant to pierce the veil of the grand jury secrecy. However, if there's evidence of some real irregularities or misconduct or misuse of the grand jury or unethical conduct by prosecutors, it may be that that grand jury veil of secrecy can be pierced and the judge and the defendant can scrutinize what went on in the grand jury. Do you think this could be one of those rare instances where the judge would let James Comey's lawyers see what went on in that grand jury?
I do, and that is because the sort of presumption of regularity that attaches to the actions of prosecutors who are taken to be officers of the court, meaning that they have an obligation to tell the truth to the court, and also they have ethical obligations that attach to how they handle any criminal case. That presumption does not really apply here. The fact is that the origin story of this case is sordid. This is born out of direct orders by the President of the United States to go after a perceived political foe. So, as we talked about before in another forum, this will no doubt result in the filing by the defense of motions to dismiss for vindictive prosecution and selective prosecution. Both of those motions go directly towards the prosecutor's conduct in bringing the case, and they are routinely accompanied by a request for discovery. So if the judge, in the event that the judge decides at the time of the filing of the motion and at the time of the government response not to dismiss the case, defense counsel routinely ask for discovery. In fact, this is something that accompanied the motion recently filed for the dismissal of the case against defendant Abrego Garcia on the same grounds, vindictive prosecution and selective prosecution. They accompanied their motion with a request for, in the alternative, discovery. The discovery that they would be seeking, and the discovery that Mr. Comey's lawyers would be seeking, would be discovery into the very process that you're referring to. And all we have to do is take several events and look at them in sequence, and you'll see why the grand jury proceedings, ordinarily confidential, could be invaded here by way of a judge's order. We have the President Trump's blatantly, I would say, unconstitutional order to the Attorney General. We have then the resignation / firing of a U.S. attorney in that same district, EDVA, who refused to prosecute this case. We then have the appointment of someone who is blatantly unqualified and is purely in that job to serve as a White House lackey, going into a grand jury and returning an indictment in a very, very nuanced and significant case in a matter of a day, without, by the way, and we know this from public statements now being made by a former FBI official named Andrew McCabe, without having even spoken to Mr. McCabe. And just to give to summarize here, the offense on which the alleged offense that this indictment is based on goes down to one transaction between two people in one room, one or at most two transactions, and those two people being Mr. Comey and Mr. McCabe. And it is the classic case that you and I would never have prosecuted to begin with, of perjury based on lack of corroboration. In other words, in this case, a he said. All right. But here you have the he said being Mr. Comey without the benefit of the he said being Mr. McCabe's live testimony before the grand jury. And so this screams out that some form of misconduct may very possibly, and in fact likely, have been committed, and it will be up to the court in ruling on that motion when it's filed to potentially grant the motion by the defense to invade the grand jury's proceedings here.
Yeah, I'm glad you kind of put a bunch of factual meat on the legal bones. And, while you were talking about the possible misconduct in the grand jury, I was thinking of the Breonna Taylor case. People may recall that Breonna Taylor was killed by some police officers when they, I believe, were trying to execute a warrant at either a home that was the wrong address or a home at which somebody else used to live, that was the true subject of their investigation. And, shots were fired. Breonna Taylor was killed. And if you'll recall, the grand jury originally declined, and I hope I have the facts right. This is now a couple of years ago from when we were discussing it, when I was discussing it on air and in my daily videos. The grand jury declined to indict any of the police officers. And what the prosecutors seemed to do was sort of hide behind the grand jury's decision. Um, and they claimed that, look, we couldn't do anything because the grand jury did not want to indict these police officers. But then some of the grand jurors reached out to the judge and, in substance, signaled to the judge that they're not quite so sure they got the evidentiary presentation from the prosecutors that the case deserved. And legally speaking, all hell broke loose. And then there were motions to release the minutes of the grand jury to see what had gone on in there. And as we all know, there were some charges ultimately leveled in that case, contrary to what the grand jury did in the first instance. I think that is a somewhat recent example that was in the news that shows how the grand jury process can be hijacked by unethical prosecutors. So let me do this now. Kevin and I spoke before we jumped on this call, and because this is going to be a recurring segment that we're calling the Prosecutors Verdict, we drafted up 3 charges against or involving Lindsey Halligan's first court appearance in the Comey case, as evidenced by that transcript we read at the beginning. The 3 counts are: count 1, she's charged with incompetence; count 2, she's charged with imbecility; and count 3, she's charged with being a Trump flunky. Do you want to first render your verdict on those 3 counts,
Guilty,
Kevin?
guilty, guilty, guilty.
I'm with you. Beyond a reasonable doubt, Lindsey Halligan is guilty of incompetence. She's guilty of imbecility, and she's guilty of being a Trump flunky. I have a feeling that the sentence that she might suffer eventually is being referred to her state bar counsel for an ethics investigation. And after a hearing, if she is found to have engaged in ethical misconduct, then the question of sanctions will be taken up. She could be suspended, she could be reprimanded, but she could be punished up to and including being disbarred from the practice of law. And I'll tell you, given the egregious nature of what we have just seen thus far, it's hard to see how Lindsey Halligan doesn't ultimately go the way of Rudy Giuliani and Kenneth Chesebro and Jeffrey Clark and John Eastman, all of whom have either been disbarred or are pending permanent disbarment. I will add as a footnote, Rudy Giuliani has been disbarred twice over, once in New York and once in Washington, D.C., because he was a member of those 2 bars. So, yeah, I do not think this case is going to play out well for Lindsey Halligan or any prosecutor that has the poor judgment to enter the fray in this vindictive prosecution of James Comey. So, Kevin, any final thoughts?
Just, I mean, what is interesting to me, and it's just a real commentary, is that it really, someone reading that transcript might feel sorry for that lawyer. And might somehow feel as if she was put in a difficult position, had no experience, didn't have a chance to, I'm sure, absorb the particulars of the file, hadn't even cracked the U.S. Attorney's Manual, which is the ethical, which sets out the ethical guidelines for prosecutors. But the fact is that, okay, sure, she's somebody who knows how to fix a car, and she was tasked with the job of going in to fix a nuclear reactor. All right, but that car mechanic doesn't have to take on the job, and it's not only it's not only something that sometimes happens; it has to happen when a prosecutor is tasked to do something that they are that is not ethical. It is up to them to back out of it and to take steps to make sure it doesn't happen to the extent that they can. She put herself in this by taking on this job, and I have no sympathy. And the verdict is solid and righteous across all 3 counts.
And if you all watching this video will drop me a note and let me know if you would like to see more of the prosecutor's verdict. I think Kevin and I, there are so many legal issues kicking around in the courts right now, and we would like to jump on and do this pretty regularly. And if you found it helpful, interesting, amusing, just drop me a note and let me know. If you're like, yeah, Glenn, why don't you focus your attention somewhere else? I am always happy to hear constructive criticism. I mean that. I crave it. It helps us get better and ultimately deliver legal analysis to you better. So drop me a note. With that, Kevin, thank you for jumping on. I know we're going to be jumping on early and often, given the illegality of Trump and company.
Well, thanks for having me again, Glenn. It's a pleasure.
All right. Talk soon.
All right. See you now.
See everybody. See y'all.